So we have, in true CPD fashion, we're going to have a horizontal line of very august personalities, all crunched around a small table with a whole lot of microphones. And this isn't enough, because in about 2 minutes, Estelle Mass will run in saying, "I'm here. Her tram has been delayed." So welcome to a very early morning session for a lot of us. And we're going to discuss why it might be necessary to go to court and what the problems of doing so may be. Now, let's do a quick round of introductions. And
recording in progress.
Let's do a quick round of introductions. My name is Johnny Ryan. I work for an NGO called the Irish Council for Civil Liberties. Romain Robert here is from the Belgian Data Protection Authority, where he is a member of the litigation chamber. And he also is a senior part of NOIB. Beside him is Michelina Nadalna Peters, who is a legal academic and is at EDPS also. And beside her is Anton Ecker, who is a Dutch lawyer and legal academic also. And beside him is Alexa Pato. Pato? This is my best Irish pronunciation of your name. I'm trying 2 different alternatives. And she is a legal academic who happens to have written a book about this topic about 2 years ago. Well, published 2 years ago, probably wrote it 3 years ago. So what I want to find out from her is, what did she get wrong in her book? How has reality actually been different to how she anticipated things would be? And we will be joined by Estelle Mass. For anyone who doesn't know her, she is one of the most effective lobbyists for greater privacy protections that we have. So let's start off. The title of the panel is here's Estelle. This is all arranged, by the way. She was supposed to run in and say, "See you all in court," but she's decided to go a little bit low-key. Thanks, Estelle. You have also been introduced. So the title of our panel is "See You in Court," and maybe it's useful to start off with Romain, who is seeing people in court, and he's also seeing people as a member of the litigation chamber of the Belgian Data Protection Authority. So Romain, maybe will you start us off by maybe explaining what the idea of the panel is? I mean, why we're now celebrating 6 years after the GDPR. Why are we even talking about court? Because surely the data protection authorities have made all that redundant, right?
Of course, because we don't need the court, right, to enforce the GDPR, as you know. Is the mic working?
It is now.
Yeah. And the anecdote is that, I don't know if you remember, when I saw the title of the panel, I really wanted to join because I think the enforcement of the GDPR was not really, let's say, working as good as some people pretend so. That at NOIB we just decided to go in court this year, especially this year, just to fill the gap between the enforcement as it should be and the enforcement as we would like the enforcement to be. So this year we want to have like 3 avenues to go to court. The first one is just to challenge the lack of reaction of the DPA. So the DPAs who are not taking a decision, and especially after 4 years, we just think that at NOIB is a long time. We will challenge the inaction of DPA. We will also challenge the decisions of DPA when we have one, when we don't really like the result of the decision. But also we decided to take the avenue of collective redress, and I think it's a hot topic, especially this year, since the Collective Redress Directive should be implemented by the end of this year in all member states. We are preparing ourselves to go to court as a collective redress mechanism, so not only against the DPAs, but also to enforce the GDPR in court. And maybe we can talk about that later, but in this context, NOIB was qualified as an entity in Belgium to start collective redress actions before the Belgian court, because Belgium is quite open to organizations which are not Belgium and accepts Austrian organizations like NOIB to be qualified to start collective actions. But we also created a foundation in the Netherlands called QUIC, informally for quick CUIC, which is a foundation in the Netherlands, when we can also start collective action. And quick might stand for see you in court as well, who knows? And it does a little bit. So that would be the 3 avenues that we were thinking of at NOIB to, let's say, complement or just to trying to help the DPA to enforce the GDPR where it doesn't work. And in this regard, I would just maybe discuss how we would just see things later. I don't know.
Yeah, okay, that's a good way to do it. Maybe as we're starting off, we should set the context for the wider discussion. Maybe a good way to do that is to ask Estelle, you were involved in lobbying in the negotiation on the GDPR, and you and your colleagues had a particular idea of where we would be now, as you had when you were writing your book. What is the difference now between what was intended and where we are now?
Thank you, and apologies for running slightly late. As you mentioned, I think a part of this panel is also discussing why we're here and where we expect it to be, and what is the issue if we're not where we're expected to be. And as many of you will know, the main enforcement mechanism foreseen under the GDPR is an enforcement where a complainant will go through the Data Protection Authority. It gives a central role to the national authority and the EDPB into enforcing the law. And sadly, we're not in this situation for a wide range of reasons. Some of it is DPA is not having enough resources for the enforcement. Some of it may be some political difficulties, and some of it is also issues at national level with legislation clashing with actually the GDPR on how the mechanism for coherent and harmonized enforcement is supposed to be working, but cannot function with 27 national procedure. And so the unfortunate reality we're in is that nearly 4 years in, we see that the GDPR is still sound as a legislation, but we're basically in an enforcement failure from the main mechanism, which is access towards the DPA, which forced a little bit organization like the one from Romain and many others to then look at other opportunities and go to court, which was always going to be a mechanism foreseen, and they were always going to be a part of going to court for enforcement and clarification of the law, but that was never supposed to be the main enforcement mechanism. And here, obviously, when we're discussing why we're here because the enforcement is not working and who is responsible for that, I think it could be very easy or simplified to point to the DPA, who obviously have a central role in that, but ultimately who's not doing its job, it's the European Commission, who is in charge of making sure that adopted EU legislation is appropriately applied and enforced through the EU. They have a role as the guardian of the treaty, and for the past 4 years, they've been doing monitoring. So they're aware of the issue and they know they look at it. But now we need to move from, okay, you've seen it, you've analyzed the issue, it's time to move. It's time to move through infringement procedure where needed, but also thinking of maybe those national differences in procedural law is a thing that's going to block the DPA from effectively applying EU law. And if you want your EU flagship regulation to succeed, you'll need to have additional legislation that makes sure that the enforcement mechanism actually works. We can't be going year on year, noticing 1 or 2 big cases as but see, progress is coming, when it's only an anecdotal case, which is very important, sure, but the amount of jurisprudence that is not happening because of the backlog of cases, this is tremendous. It's a huge loss, and it runs the risk of companies stop caring about GDPR because it's not enforced, and people also just losing the illusion of okay, maybe I won't be able to gain back control because at best it will take 5 years, and most of the time I actually hear nothing. So we need to start putting back the responsibility on the Commission to fix the flagship they've created for the GDPR to work in Europe, but also for a little bit the repetition of Europe as a global standard setter on data protection.
Michelina, you came up with the idea of this panel. You brought these people together. It's all your fault. So let's blame you. Now, what we're hearing is that there's a problem with the intended enforcement arm at the data protection authorities. And so we have this safety net, this valve that we can use, which is going to court. but you think there's a problem when we go to court. It's not all so clear-cut. Elaborate.
Yes. Thank you, Johnny. Indeed, the GDPR is only as strong as its enforcement, and as Estelle and Romain have mentioned, it's clear something is not working. So we are currently seeing, let's say, a shift to other avenues for enforcing the GDPR, and those are the courts. Indeed, litigations are coming, and my panelists will tell you more about that, but it doesn't mean that there are no challenges. In that respect, what I would like to propose or argue today is that the issues that we're seeing right now are stemming from not enough harmonization. And here I would like to make 2 points. The first one concerns the existence of way too many opening clauses in the GDPR. And the second point that I would like to make to highlight my statement is that we actually do not know the notions of the most important aspects and requirements for any compensatory claims. When it comes to the first one, so the opening clauses, it depends who we ask, but some people say it's 80 or 90 opening clauses. And they allow member states to complement, divert, or otherwise allow member states to actually come into the, the material of legislation of the GDPR. And here I will take an easy example. Let's talk about the consent age for minors. So Article 8 of the GDPR. Here member states were allowed to legislate differently. And they did so. Belgium, 13 years old as the age of consent for the minors. Spain, 14. France, 15. Poland, 16. So now the question is, when we have a Belgian teenager, let's say using dating app from a company established in Poland, and then we have a conflict, let's say processing that is not lawful, which law will apply? Which age of consent should be the one that will be the one considered by the court as required? Now here the issue that we have with the GDPR is that unlike with the directive, there is no clause that would help us identify the law that is applicable. Yet this is the core and first question that should be asked in litigation. And here I'll just make since we do not have an opening, we do not have a clause that would regulate that, we might have to fall back on the standard instruments of private international law of conflict of laws, so Rome regulations. But even here, we are not certain if they can apply, which basically means that in case of a conflict, the law applicable will most likely depend on the court that is seized in a given case. So it might be that the Polish court would use a different law, would use a different age of consent, and the Belgian one a different one. And the issue here is that it's not consistent. And now moving to the second issue. The key procedural aspects of private claims before the courts are not harmonized. When we look at Article 82, it all seems clear, right? We need an infringement of the GDPR that results in a material or non-material damage. So let's say these 3 aspects, requirements seem fairly clear-cut. But are they really? And here we're already observing that the Court of Justice is being asked whether these notions of what is an infringement, what is a non-material damage, are these notions actually autonomous notions under the GDPR, or are they actually to be interpreted under the national laws of the courts that are being seized in given cases? And here there are many actually cases pending from the Court of Justice, but let me tell you about 2. One coming from the Austrian Supreme Court raises a very important seminal question even. Here the court asked whether an infringement of the GDPR alone is sufficient to get compensation, or whether we need an infringement and to show a resulting damage from it. So here really it goes down to the causality, to what a data subject needs to prove in court to be able to get compensation. And the second one in that respect is really the question of what is non-material damage? What type of severity do we need of a non-material damage to show to ever get compensation? And here there's an interesting question coming from the German Supreme Court that basically is asking the Court of Justice whether a sole discomfort of a possibility of misuse of somebody's personal data is sufficient to establish that there is a non-material damage, and therefore compensation should be awarded. And in here, an interesting point I think to note is also that the German Constitutional Court did highlight that it is essential that the Court of Justice actually rules on that case, because we do not have clarity. There is not enough case law, and there is not the Article 82 in itself is not sufficient to make to decide on what the notions of those key requirements are. So to conclude, I do think that we do not have enough positive harmonization, and as a result, the GDPR in that sense, even when we go to court, fails to provide consistent protection of individuals. And a point of reflection that I would also like to leave, and maybe for a further discussion, is it's a Court of Justice that will be now deciding really the core aspects concerning compensatory actions in front of the courts. And the question that I myself am posing myself and posing also to you is whether we want the Court of Justice actually to decide it. We will be seeing a sort of negative harmonization, and it's not the legislator that actually will decide on the framework, but will be the Court of Justice. And it will be done so without much democratic participation. So it's a question whether it is the direction that we also want to head into. And thank you so much. And I forgot to make a disclaimer that those were my personal views and not those of the EDPS.
No, too late. Sorry.
Too late.
You say these things at the beginning. That's now out of Wojciech's mouth. Okay, let's leave the question about whether the ECJ is the one who should be nailing these things down. Maybe till the end, because it's a big question. Maybe we can build up to it. We may not get to it, but let's see. Okay, you put a lot on the table there. I didn't interrupt you because it was all good stuff, and I can barely remember most of it, so we might have to come back to you. But I want both of you to try to, well, first I want to know whether you agree with these points, whether there are problems of harmonization, and whether they are, as you specified, whether they relate to the harm, and also procedural matters. Let's start getting into that. So I'm going to start with Alexia. As I said, you were in the at that point probably good position of seeing exactly what it said on paper, because we had the GDPR finalized. You started to write your book about collective redress across the EU, not just about the GDPR, but then history happened, and of course there are going to be things that surprised you. So not only do you agree, but was the situation we're in inevitable, or have things happened since you were looking at this for your book that surprised you?
Well, thank you, Johnny. I must admit that I agree with what Michalina said. I think that the interpretation of Article 82 will have an impact probably on collective redress litigation, right? Because if the interpretation of the notion of damage is broad enough, then it will probably generate more litigation, or at least it will become more interesting to litigate and use collective redress. So I agree that what the Court of Justice will decide in that regard is important. As regard collective redress and the book that I wrote a few years ago, I wrote my book on collective redress, cross-border collective redress, and jurisdiction. So I observed the situation from two angles, from the procedural angle, collective redress, and then jurisdiction, the Brussels 1 bis regulation. As regard collective redress, I do not see many changes, although I must admit that when I started my PhD on collective redress in 2013, and there were still many member states lacking any procedural tool on collective redress, and some of them, they had that tool, but it was not really used, not really efficient. So I think that now we are going in the right direction, because since the recommendation of the Commission of 2013, there has been reforms at the national level in order to improve the efficiency of collective redress procedural tools. So this is a really positive element that I would like to highlight. There are nevertheless still inefficiencies, so some collective redress mechanisms still impose very strict standing to sue requirements. There are also funding issues that has not to do directly with collective redress, but it has an impact on it. So the basic idea, which was, let's say, surrounding the debate on collective redress when those laws were adopted in the first place, still is present, which is that we want collective redress, but not that much. So that remains exactly the same. As far as private international law is concerned, there hasn't been many changes. In my book, I suggested that we should adopt a special forum for cross-border collective redress claims. Nobody seemed to agree with me so far, but I think the time would be ripe to rethink a little bit our private international approach to collective redress, because obviously it is not really working. And now the problem is that we have overlaps of regulatory regimes, both for collective redress and jurisdiction, which makes the whole landscape totally confusing, and I don't think it's really handy for market players to use those rules. So that's what I would say to summarize a little bit the situation and my observations.
Anton.
Thanks, Johnny. Well, I think I agree with many of the points, but still my perspective is a little bit different. You know, I'm an attorney, and I've been handling a few GDPR cases in the last few years, such as the Siri case about the risk indication system in the Netherlands, and currently the Ola and Uber cases. And I would say, to me, it's not really a surprise that the DPA don't take action. I didn't really even consider to go to the DPA, to be very honest, because I thought, well, it's going to take ages, so let's go to court. And also, I don't see going to court as a safety net or a last resort, which you only use if the DPA doesn't take action. I think the courts, they are an instrument in their own right. Courts can do many things that DPAs cannot do. They can strike down laws, for example, which they did in the Siri case. They struck down the Siri Act, which allowed the court to use this risk indication system. They can award individual damages. They can award group damages. They can make declaratory judgments, to define legal relationships. So I would say, I'm very pragmatic. I will say, let's go to courts and worry about consistency and harmonization later. Just start working on the law. The court can also overrule automated decisions, for example, which DPA cannot do either. Now in the Netherlands, we have a new piece of legislation that allows also to bring mass damages claims on GDPR infringements. We see the first case also, Salesforce Oracle. So I think you could also reverse it and say judgments by the courts could pave the way for DPAs to take action. Because if the judge decided that this was really an infringement, it's much easier. You can just impose a fine,
So let me ask you, Anton, are you surprised we're not seeing more litigation across the EU? I don't just mean in the Netherlands.
Yes, I'm a little bit surprised, because I think there are so many possibilities. So instead of talking about the problems that there still are, we should just build coalitions, build awareness, and go to court. Okay. Why not?
So it's taken us 25 minutes. 25 minutes in, we have our first almost disagreement on the panel. A whole lot of people saying, yeah, DPAs aren't working hard enough. Yeah, we should go to court. And the divergence then between some of you is, well, there's niggles that make it tricky. And then the lawyer's like, let's just go to court and figure it out on our feet, which is good to hear. Okay, let me ask you, we've been talking about DPAs and whether they do their jobs. and we've been talking about individuals going to court. We haven't talked about going to court against DPAs, which is the third issue. We actually didn't discuss this when we were preparing. So let me ask you, Romain, I mean, did you anticipate, because you're on both sides, did you anticipate that that prong would be as used as it has been? Because there seems to be quite a lot of litigation against DPAs rather than against controllers.
Honestly, I haven't seen that. Oh, sorry. I didn't see the microphone either. I didn't see DPAs and microphones. But basically, no, I'm not sure. I see a lot of litigation, for example, in Belgium. The Belgian DPA has been challenged many times before the Court of Appeal. It's not the same in other jurisdictions, so it just depends, I would say, from member state to member state. Challenging DPAs is one thing, and I think it's anyways just a right which is really explicitly mentioned in the GDPR. You can challenge a decision of the DPA. The problem is that it's the other action. There is no explicit right to challenge the lack of action of a DPA. And first of all, because there is no definition of what is the lack of action of a DPA. Why? Basically, and I'm sure we all agree, because there is no deadline in the GDPR. So we never say, there is no way to say, oh, no way. There is no explicit way in the GDPR to say when
your
the DPA...
organization is taking DPAs to court.
Of course, when we can. And so how do we prepare that? So, for example, we just apply, especially with people that I see in the room, a grant with the EU to have a mapping of all national laws in the member state to see how, when, and under which condition we can challenge the lack of action of DPAs, because that is not clear, and I know the DPB is working on that as well. So that's the first avenue that we are just studying right now to know on the basic, for example, on the basis of administrative law, can we challenge the decision or the lack of a decision of an administrative authority when they don't take action, or when they don't issue a decision after 4 years? And I think it's just like, I don't need to be a lawyer to know that 4 years to have an effective enforcement of the GDPR is quite long, but apparently you still need to prove it in court. You have to prove that 4 years is too long. So we applied for grants to have the know-how. We are building capacity as well with our network, for example, EDRI, and Access is a member of EDRI. So we're building capacity building to share with other members and other NGOs in other member states, so that they know when they could challenge the lack of action of a DPA, which is not always easy as well. But there is also a court decision against DPA, which are not really positive for organizations like NOG, for example. The CNIL has been challenged many times by the Conseil d'État, and the Conseil d'État already confirmed that the CNIL had a discretionary power to close a case because the CNIL think it's not important. The Luxembourg DPA is apparently discretionary right to decide that the case is not really important, or even not, or to decide not to decide. So we have a case against the Luxembourg DPA who decided not to decide, which is crazy in my opinion. So this kind of decision...
Very decisive.
Yeah, so they just decided they didn't know whether the GDPR was applicable. Can you believe that? A DPA is like, I'm not sure GDPR is applicable. Guys, if you don't know, yeah. So we kind of challenged, this kind of decisions we challenged, that's for sure. So that's how we see things in the first place. But in the other thing, and I'm sure we're going to talk about it, I would love to go to court every day, but how do I pay for the lawyers? Yes. That's a huge problem for sure, yeah. Man, I'm happy if you want to do it pro bono for us. I'm happy.
Well, we can discuss it later, but I don't know. Do it here. Ask James Farrar. He did it.
Who?
James Farrar of the ADCU, so you talk to him. I think there are many possibilities, but to go to this, I know I've done some research for like 4 or 5 countries about this margin of appreciation that DPAs have, and if, like you say, in most countries it's very hard to challenge them because administrative court will decide that they had the right to, within some limits, to decide not to pursue a case. But maybe this is something that should be fixed, I agree.
We're half an hour in. I will ask now that you think of any questions or even statements masquerading as questions that you would like to put to anyone or all of the panel. I won't look for hands now, but just have it in your mind and I'll start glancing and just grab my eye. Before we get on to questions, so it's unfair to call them niggles, right? But there are important technical details of harmonization. Can they be dismissed in the way that Anton has dismissed them? or are there real problems waiting for us if we embark on big piece of strategic litigation? And that's for either of you.
I'm not saying those problems aren't there. I'm just saying if you wait until they're all solved, we can wait for another 10 years. So decide which case you want to do, decide what's the best country, and then you follow the rules of this country. The last week in the court hearings for Uber, the judge talked about the applicable law for 3 minutes. She asked, what do you think about it? And then Uber said, well, we didn't really think about it. I said, well, I didn't think about it either. And then the court said, well, we'll assume it's Dutch law then. And everybody agreed. So maybe that's a very good way to fix it, in a practical way, if in a specific case.
Okay, kind of
that's really how it happens. So this is I just give this to you.
That was a pretty judge-dependent outcome. It depends on the bench that day.
I think in most cases, in most countries, if parties don't take a stance, the court is going to assume that the national law will apply. I'm not sure. Maybe that's too.
I do not think that we are advocating that there should be no litigation until we fix this. Obviously not, and that the Court of Justice is being asked to clarify is fundamental and is seminal, is of huge importance that can actually allow us to go forward. But it does not mean that what is problematic should be avoided. We should actually sometimes maybe challenge, really go head on and try to fix those issues. Private international law is notoriously forgotten, as Anton, you I think made a point to show. Which does not mean that it's not problematic. In fact, it can be a grounds of appeal in certain jurisdictions afterwards.
We'll see.
So even then, when we have a final judgment with legal effects, it can be challenged on those grounds. So this is just a remark. But in any case, the broader issue that we are, I think Alexia and myself, but also Estelle mentioned, is that the lack of procedural harmony between member states is actually endangering the goal of the GDPR, which is consistent protection of individuals. Of course, in practice, we can go and we can select, we can do strategic litigation, we can make forum shopping, and we can decide which court is better to litigate in. But the point is that it's going to advantage only some individuals who actually happen to have access to particular courts in particular member states, because let's not forget that the GDPR tells us which courts to go to. Of course, it's also an unclear point, but at least we know it can be a country of habitual residence of a data subject, or where the controller or processor is established. So we're talking 2 member states. And if we're lucky enough, yes, there might be good countries to litigate them. And if we're not, then what happens? Then we have a data subject who basically does not have access to enforcement of the GDPR, to having their fundamental rights enforced. And so this is the problem. Of course, so let's litigate, let's try to fix it, but let's not forget about the bigger problem and the bigger goals that the GDPR was aiming for.
Which are? Sorry, you just left that hanging.
Consistent protection.
Okay. And sorry, just before Estelle, Alexia, do you want to come in on that?
Just quickly, I think I agree with Michalina in the sense that, first I understand what Anton says, and I know that private international law issues are most of the time bypassed. I have 130 students, and believe me, they do try to bypass private international law questions. So that's an attitude that I can, or an approach that I can understand. However, if you apply default rules of private international law, you ensure harmonization and you ensure legal certainty, because you know in advance what the law applicable will be. For example, if we are talking about applicable law. So yeah, summarizing, I agree with Michalina.
Estelle.
Thank you. Maybe just an observation that our starting point was, okay, there's an issue with GDPR enforcement at the DPA, let's do GDPR enforcement in the court. But it looks like most of the litigation that's happening right now, it's even to clarify how and who can enforce the GDPR. We're not even enforcing really the GDPR, but asking who can do it. And when we have sometimes even court cases, then it gets challenged by the data controller, like, you didn't have the right to do that. And I understand the interest of going to court, obviously, as the DPAs are not functioning, but if you don't fix the harmonization that is an issue for the DPA enforcement, you fall in the same issue in the court, because you will have the data controller challenge it, and you will find yourself in court still arguing no longer really about the material issue and the data protection violation, but always who can decide and how can you decide and what can do that. And I mean, it's a little bit like when Max Schrems challenged the safe harbor, afterwards everyone was like, oh, everyone can do that. Like, Max is brilliant, and not to say that not everyone is as brilliant as him, but like not everyone has the time, the energy, or the resources to do that. And we can't ask all the data subjects to be like, well, go to court and like face really long appeal against huge data controllers that the DPA themselves cannot face. And so if we don't solve those problems of the lack of the details that Romain was mentioning that are not in the GDPR, that we sort of all hope that, well, they'll figure it out. Like, we need to address those now, because if not, we'll just spend years of like procedural litigation, but no really addressing data protection violations.
If I may, I'm sure you've seen it, but I think 2 weeks ago I've seen a pending question in the Court of Justice whether you could go to the DPA and to the court at the same time for the same problem. Yeah, so this question is also pending in the Court of Justice. So this is not even solved. This is not, for me, it was obvious you could go to the DPA, to the court. Apparently it's not obvious for everyone. And that's the controller challenging the capacity for the complainant to go to court and the DPA at the same time. So they just do everything on a procedural level just to avoid the GDPR infringement. And it's true, not on the merits, but just on the procedural law. So we're still waiting for the answer.
We were discussing in preparing that panel, at the moment, who is in court challenging the GDPR? It's Meta. It's Meta who's challenging everything, and it's actually not us. They're challenging the EDPB decision, they're challenging when and who can enforce the GDPR, they're challenging if you can use it with jurisdiction and other. They are bombarding us with court cases for the GDPR not to be enforced. And this is part of the problem of, like, if you leave uncertainty, it's always at the expense of the data subject.
That's a great line. There was a panel yesterday, and Rebecca Slaughter, I don't know if she's here, from the FTC, was saying she's really sick of companies saying they want legal clarity, but also lobbying so that the FTC can't do rulemaking to impose legal clarity, because a lot of the stuff would then be made black and white, red line, unlawful. Are there questions at this point? Oh, there are. Okay, well, you were very fast, so let's start with you.
Hi, I'm Linda Thompson. I'm the Brussels correspondent for Law.com. I would like to get the panel's thoughts on how do you feel about U.S. litigation firms specifically funding GDPR class action lawsuits, particularly the arrival of litigation funders also from the U.S. Do you think this is something that will benefit consumer data subjects?
She was so fast, wasn't she? Notice that it's the journalist who's like, no messing around. It's like a Dublin taxi driver compared to all other drivers. Okay, who wants to start?
Yes.
Okay. I was wondering if I could get the panel's thoughts on how they feel about the arrival of U.S. litigation firms, specifically in the Netherlands, and also U.S. litigation funders that have really discovered the Netherlands as a jurisdiction where they can do class action suit, specifically in the area of GDPR. And do you think that's a positive development for consumers?
Well, can I answer that?
You certainly can.
I happen to be in the board of the Privacy Collective, which has brought the case against Salesforce Oracle, and they are being funded by a UK litigation funder, but in the end I think they're also American. Yes, this case would not have been possible without this litigation funder, so in that sense it's positive. And they all have to comply with Dutch rules, also relating to the governance of this, both of the funder and the claimant. So I don't see a real problem there.
Just before Alexia. Roma, you were about to answer before she repeated her question.
I agree. I would say why not? Why should it be a problem? But I think I understand your question as well. We are also preparing collective action in the Netherlands with our foundation as well. We are calling upon a funder, not coming from the US, but they're definitely not coming from Belgium. But there are a lot of funding and third-party funders in the EU as well. So we approach, I would say I have 2 calls a week to fund the case at NOIB. So I think money is not going to be an issue. If I should, hopefully. Maybe I'm talking too fast. And if you have more funder coming from the US, I don't see why it would be a problem. But as Anton said, I think the rules in every member state will be different. So in the WAMCA law, in the Dutch law, you have specific rules for the transparency on the funder and everything. So in Belgium, it's not the same. The problem is that the industry is lobbying hard on the member states to prohibit the funding of the litigation by third-party funder in the member state right now. So we are. I know that some counter lobby is also done in this respect with the member state, because the collective redress mechanism without third-party funding mechanism is not going to work. This collective redress is going to be nice to read, but it's not going to work in practice. If the money is not allowed, there is no way for the money to come. But we will find our way, because we're working on work. No problem. We're going to find the money. It's already on the track list.
I agree with my colleagues. I am pro third-party funding from US law firms. So, but you would perhaps be interested to keep an eye on the initiative that is currently being discussed at the EU level on third-party funding, because this initiative actually restricts third-party funding to persons that have a registered office in the EU. So they do it in the name of abusive litigation. I'm personally not really convinced by this policy objective. I have the impression that this will, at the end of the day, limit access to third-party funding for people located outside the EU.
I think one of the limitations is that they will only fund you if you have a big mass damages claim. So you cannot do a principled case which is not about money. Yeah.
Yes, so as a result, we're going to have possibly a fragmented enforcement, right? Because the money follows certain issues, but not necessarily others. So it might be not in the interest of the money to look at some, and so we will have, it will be selective.
Okay. Any, Gloria.
Hello, everybody. Thank you for all the presentations. I have a question probably for Alexia, because we have mentioned the GDPR and the Collective Redress Directive, and in my mind, I always simplify things, like saying the Collective Redress Directive is very much about cross-border cases and pushing, understanding these cross-border things. And I thought the GDPR is not about cross-border, facilitated cross-border litigation. But then I see NOIB that has been done a lot of cross-border things. Suddenly they start creating like local things in the Netherlands, in Belgium, for the collective redress. And I don't understand anything anymore. So could you explain this to me, why in the context of this collective redress, it's so important that actually you cannot do things from Vienna? Does it make sense? What's the logic? Thank you.
Yeah, it's strategy, so I'm not sure I want to disclose everything. This is really, we can discuss around a coffee, yeah. So this strategy, but I understand. I think the collective redress is not covering, but I can't say too much. It's not covering all aspects. I think collective redress is full of gaps, and I want to fill the gaps before they are, and see you agree, you know what I'm talking about. I want to make sure that I'm just ready for the collective redress, and we will be ready, trust me. But I see that some gaps are still in the text, and I don't want to fall into these gaps. So we're spreading a bit.
Let's take a few more. Sarah. No, you don't put your hand down.
So thank you for the presentation. It was really interesting. But for my question, I will just put my hat of a citizen and of a data subject. My question is about expertise. I do agree that, for example, when we will talk about a lack of information to data subject, or maybe bad privacy notice, I do believe that the national court will be able to handle the cases. But what about some complex situation, like for example the use of AI? Do you think that the court will be able to investigate better than some data protection authorities? So that's my simple question.
Yes. Well, expertise is a recurrent issue of the courts. This really does not concern data protection and AI, and it also really goes down to how member states actually organize their legislatures and how whether judges are allowed or not to specialize. So in Poland, that's not really a thing, and this is really a challenge. And in that sense, indeed, it might be if judges are swamped with questions, technical questions that they are not competent on the technical level to understand, it indeed might endanger the enforcement. At the same time, it also, as you mentioned, it maybe is an argument why it should be the data protection authorities dealing with certain issues as a first instance, because perhaps the expertise and the specialization of a data protection authority might be higher than a court. But this, Anton does not agree.
I don't agree. No.
Great.
So first of all, I think how can we expect judges to know data protection law if we never bring cases? So we start litigating, and then finally they will have to study the law. So we must force them to study the law by bringing cases. That's my whole point. So in the district courts, the judges were clearly annoyed about this stupid GDPR. They didn't understand it, and after 2 hours they just gave up. But then we went to the Court of Appeals, and now we have judges that really took the time to study all the documents, and they asked really specific questions. So I'm optimistic.
This reminds me of a story from, I have to tell this story from 2007, I think. And there was a suspect in the UK who was accused of being a facilitator for people who wanted to go to conflict zones to fight in the Al-Qaeda effort. And this young suspect apparently had the online name of Irabi 007, right? It was like a militant 007. And he operated from his parents' basement, an entire network for recruitment. This is what the authorities claimed. On day 2 of the hearing, Mr. Justice Peter Openshaw, I remember this, paused the entire thing and said, I'm sorry, I don't understand some of the technical phrases being used here. And the barrister, someone like you, said, Judge, how can I help? What's the word you don't understand? And the judge said, I don't understand what a website is. So on day 3, some expert from, I think, UCL, University College London, came in with a graph showing a computer connected to a globe and the cables. But he asked, they can learn. Now I don't know where we were. More questions. Sir, over in the corner.
Chris Doxey, Honorary Director General of the EDPS. Just in terms of strategy, what we've already established is that the courts may not necessarily know that much at the moment. We know that data protection authorities are and should be experts in data protection law. Wouldn't it be a good strategy to say, aim for the data protection authorities, because that's their job, get a decision out of them, which is reasoned, and then, and that's what they said you should do in Digital Rights Ireland in the Court of Justice case. Then, if you don't like the decision, go to court. Don't wait for the Court of Appeal or the Supreme Court to take years and years, but ask the first instance court to send it straight to the Court of Justice. It's always been a problem that we waste so many years going up and down the legal tree. I know it takes time to go through a DPA, but there's case law on that saying it's good to have an administrative review of the facts. You've got for the court at that point an expert appreciation of the situation. So my question is, isn't this a good way? Isn't this a better way than thinking, oh yes, let's wander off to the courts who may or may not know what they're doing and spend the next few years training them in this way?
Thank you, Chris, but the answer is clear, no. It's not, 4 years ago, I would have said, yeah, let's wait, but I'm sorry, it is not working. We're waiting 4 years to have a decision of a DPA. I cannot wait more. It's going to be more efficient in a court. We have cases, and we published a table with our cases, for example, the one introduced and filed 4 years ago already. Only 15% of our cases being dealt with by the DPA. We're still waiting for 85% of our cases. And I just see here and there that one-stop-shop is working, and I don't really care about one-stop-shop. This on the national implementation and enforcement is not working either. So it's nice to have statistics to see that 85% of the cases are dealt with, but our cases are not dealt. So lucky the other ones, because the other ones are really lucky to have the case having a decision by a DPA, but we don't have that. So I think, no, we're just out of patience now, and we want to go to court because it might be more efficient, because that we even don't know. It is going to be costly. It's true that the decision of the court is like random, like really sometimes you don't even know whether they understand the GDPR. So it's also risky because they might have a decision that you really don't like. It might be also quite long. And also sometimes surprising, because the WAMCA in the Netherlands was supposed to be the place to be for the collective redress, and I'm sorry, but it's not that great after all, because how many decisions of collective redress in privacy enforcement have we reached so far under the WAMCA in the Netherlands? It's still
none,
not really...
but
Voilà,
this will take a little bit of time.
Yeah,
yes,
but
it's true. But
it's true, 4 years as well. So I'm not totally convinced that the WAMCA and the collective redress will be the only avenue, and I agree with Michalina. Great for collective redress and like damages, but what about this guy who was just asking for accessing these informations in 3 years? There is no funder who are going to fund a collective redress mechanism for an access request, and I think those people should not be ignored, you know?
It's not true.
Sorry, Estelle was very politely...
Sorry, Estelle.
Sorry.
Apologies.
I mean, I agree. In practice, this is the way I think all of us wanted the system to work, you know, going through the DPA. But as Romain said, we're still stuck in phase 1, 4 years on, and most of the cases are not resolved, or we get no decision or no information. So we're stuck there. We might be stuck in court also for a long time, and potentially with people who don't have the expertise. So again, I'm sorry, like, where is the commission? Please move and like fix this, because we can't have every way we try to get remedy. Each time it's like, well, we don't know, we don't have time, we don't have resource, we don't respond to you. And then we just, I mean, great, so we do legislation, we put it in the drawer, and we move on to the next legislation where the same thing will happen. So great, we're the superpower in legislating, and someone else will enforce, I guess. But.
We know where the commission is. Luckily, I have a very big phone so you can all see. Zoom, zoom, zoom. If anyone wants to look at Didier Reynders, that's the European Commissioner for Justice's Twitter account, we can see where he was yesterday. He was having a photo op with the Irish Data Protection Commission. It's on his account. And we're waiting for von der Leyen to reply to the European Ombudsman with a specific accounting for what information the Commission bases its assessment that Ireland has correctly applied the GDPR. And that should be coming tomorrow or the following day. I think it'll make interesting, perhaps even creative reading. So let's see where the Commission is. But you're right, so far, nowhere. This raises a question, maybe beyond the scope of this panel, but will we see anyone in court against the Commission? And I don't just mean for an infringement procedure. Are there interesting creative things to do? Creative thinkers? Or do you want to just mull on that and maybe come back later?
Are you going?
Maybe. We'll see in 2 days, exactly. Probably. Any questions? Down there.
Hello. Thank you for this very interesting panel. I have really one quick question, which is out of curiosity. You've talked about different courts, different procedures, different countries. I haven't heard you about criminal courts. I don't know if it's anything that you studied or that is part of any strategy, knowing that I don't know if it's the case in all European EU countries, but at least in some of them, probably most of them, GDPR infringements can also be covered in criminal law. And I'm not saying that you should jail all data controllers, because that might be a bit harsh. But I was just wondering if that was also part of anything.
Well, you're Anton, yeah.
I'm not aware of any criminal accusations or anything. No, sorry. No.
I was about to jump in straight away.
Yeah, sorry. No, go for it.
Oh, yeah, we thought about it, but I think, okay, I don't know any court in any jurisdiction, but I'm afraid that criminal judges are even worse than the civil judges when it comes to the GDPR. So they might go in jail if they don't have to go in jail. So, so I think it would be totally unfair.
Yes, yeah.
But as an anecdote,
You're saying this individual is responsible for those cookie messages?
Voilà, here's the one.
Lock him up.
Yeah, and the judge will ask, what is a cookie? Like, I don't see any cookie. Like, we don't want to have this discussion in the criminal court. It's a bad judge.
Well, there's one example where Uber drivers who were suspect of fraud are also getting their licenses revoked because of that. And this issue is in the UK handled by criminal courts, and they actually decided that the decision based on the algorithm was wrong. So in that specific situation, they made a good decision.
I just wanted a reflection, because this is not something I studied, but I know that in Poland it is indeed, as far as I know, a possibility to go to a criminal court. But just a reflection, because it raises completely different set of issues, as Roman mentioned. Civil court, the liability in civil courts and criminal responsibility is completely different. In criminal procedures, we typically have to have an individual. We have guilt that has its completely different set of attribution of faulty behaviors, plus all of the other circumstances have to be taken into consideration. So this might not be, and of course, in some circumstances, in some jurisdictions, you might get compensation or some sort of a compensation, but this is a completely different avenue that might be appropriate to some cases, but I would argue that probably in majority of the cases, civil courts are more appropriate for that.
Hi, my name is Felix Zopp from University of Vienna. I'm currently also clerking for the State's Attorney's Office Vienna, and we had there actually a criminal case in data protection. And the problem we faced is that we had a lack of evidence, because there was evidence in a Belgium server, but the Belgium criminal authorities did not provide the evidence to the Austrian state's attorneys. So we had there kind of facing that we couldn't get the evidence actually right to handle the case. So it was more a problem of European cooperation to get the evidence to prosecute the case. So this is actually also the State's Attorney's Office facing the problem of evidence and procedural hurdles. So maybe there are other people who have experience with this, but this is probably also an additional layer of problem. So the European cooperation in this area.
But this was just to us. This was because of the unwillingness of the Belgian side, because there are mechanisms to seek evidence in cross-border cases. So
it was a European
microphone. Could you take your microphone?
It was a European investigation order, but they did not answer, I think, over a year or so to this European. So they actually followed the European.
We have a harmonized way of getting the evidence, and it's still not working.
But have you heard of the EDPB and the cooperation there?
It happens with DPAs as well. I'm not sure they exchange all information as well. Yeah. Sometimes you have to wait 2 years to have information from the other
But this is the biggest problem of EU law. We write national authority have to cooperate together. We don't say how, but it will magically happen in the police sector, in the data protection sector. We have at some point to put the rules of like, okay, you have to share the document by this deadline, or so. If not, it's not going to happen. And so cases don't move on every several years, not because information isn't there, it's just not shared within EU states.
I worry as a European that we decided, our legislators decided several years ago to stake an enormous amount of political capital, despite huge lobbying effort against them, to stake political capital on this idea of data protection law. And it happened with the headwinds of Snowden and this moment where Europe, which hasn't really mattered very much, really, since World War II, right? Where Europe said, actually, we will be the global regulatory superpower, and we mean it about the GDPR. And it really feels like Europe was winking when it said that. You know, that there isn't really any more a momentum behind making this thing real. And you see it in details like that. It's deeply worrying, because if Europe can't even pull off these kind of global things, it can't really do much of anything. So you've the microphone. Would you like to, do you want to ask your question?
Yes, excuse me. It was just to state, we have a law case in France in a criminal penalty. It was against medical staff for a lack of security, which resulted in a data breach. And it was a criminal fine of 5,000 euros. So the criminal courts can get a result. But I have only one example, one single.
Yeah.
I just want to say, because I hear fines and everything is also very interesting, and we're talking about collective damages and about third-party funders. But for example, at NOIB, the main purpose for us will not to have damages, is to have the practice ceased. And that's something that you can also obtain with the collective redress mechanism. In the collective redress, collective redress directive, you have damages and or cease and desist. And I don't need that. I need less money to go just for a cease and desist in court, because I don't have to manage the class and like 1 million users and everything. So I can also go for cease and desist. Usually the funders are not interested because you don't claim damages for sure. But as an NGO, I think we can totally fund ourselves a cease and desist collective redress. We don't have to go for damages. Just something to bear in mind, yeah.
Anton, are you coming back on that? No?
No, but I think that's a good thing, of course.
Okay, so we have 12 minutes left. Maybe we can get a few questions.
Here. I have mic.
We hear you, but we do not see you. Oh, there you are.
Maris from Latvia, privacy lawyer. Can you comment a little bit Article 82 about time limitation? Because there is no time limitation for the damages action. For example, in Latvia, we have a law that not more than 5 years this can be action can be in the court. But what is your comment about this? And as also Article 83 don't have any time limitations for the penalties. So
okay, and we're going to wrap a few questions together. So let's see if we can.
Thanks.
Over here. Yeah. And then in the front row as well.
Thanks. I'm Simon Ania. I'm a DPO at Uber, which means that I'm observer to what things Anton is doing and Uber is doing, because that's the role of a DPO in these cases. But actually my question is about claims funding. And Anton brought it up. Claims funders are in there for the money. Now, what I see happening, because I also have some visibility on what's happening in the US with respect to various litigation claims, that it's always about, in the end, a settlement. So the question actually is, if you are seeking a claims funder, will you seek a claims funder that's interested in justice, or are you seeking someone who's interested in money, who will cut down funding if you don't settle? So what do you want to achieve? Justice or money? And is that reflected in the way you deal with your claims funder? In particular, when this claims funder, is, for instance, is an investment fund, a hedge fund, who has a portfolio of these kinds of claims, just like IP litigation is happening.
Okay.
So justice or money?
Okay, and then Michael in the front row. Justice or money, by the way, sounds like a T-shirt waiting to be printed.
Just a quick question. There's lots of cases that appear out of nowhere that aren't initiated by NGOs as well for various reasons, personal grievances. Is there a role for NGOs and others to intervene in some of these cases, depending on member state role, the way they organise their legal systems? And if so, what's the capacity that's needed to do that? It's not really very easy to locate these cases. Maybe we should try harder. And what would that look like?
Let's see if we can get a fourth question, and then maybe we can have a run at them. Interesting topics. Is there one final question? Yep, perfect.
I'm from Leiden University, and I'm also came from the Court of Justice, Thailand. I would like to ask the question: what would be the best position or the appropriate position for the judiciary role that you would like to see? Should we have like a specific court to address this specific issue according to the digital technology or not? Thank you.
Okay, let me do a quick recap. So we've got the time limit question about Article 82 and 83. We've got the T-shirt question about justice or money. We've got the can NGOs intervene? How might that work? And then we've got this, do we need a specialist court question? In no particular order, whichever one excites you. We've 8 minutes left, so let's see how much we can get through.
Then I'll just jump on the...
Fire away.
Thanks, Johnny. On the time limitation, well, that's precisely the issue. Since it's not harmonized in the GDPR, it will depend on the procedural law that applies in a specific circumstance. And how do we know? Well, we don't. It depends on the court. And since Rome 1 and Rome 2 regulations don't apply, and time limitation might be simply aspect of very pure procedural law. It really depends on the court that we go to. So it might very well be there in Latvia, you said, right? It's 5 years. I think in Poland it's also 5 years. But in some other countries it might be less or more, which only shows to the difficulties that data subjects have to navigate in and the need for expert representatives. So no, the GDPR does not really regulate that. Maybe the Court of Justice might be asked a preliminary ruling question on that, but as far as I know, there is no pending yet.
I would like to jump in very quickly. I think what you need to do in order to find out what the time prescription is to go to Article 82, paragraph 6, which tells you that the right to compensation is exercised under the law of the member state where you bring your claim, which is one of the fora of Article 79, paragraph 2 of the GDPR. So what does that mean? Is it a reference to the substantive law of the member states where you bring your claim? I do not advise this kind of interpretation because otherwise your time prescription depends on the forum where you litigate. So perhaps I partially agree with Michalina on that point, because I think that you need to use the Rome 1 regulation in order to find the applicable law to time prescription. That's the way I would do it.
Any more on that point? No? Let's move on to another question. Any question? Yes.
T-shirt question.
Of course, I really undermined your question. I'm sorry.
So of course I know. Yeah. Of course, it's quite obvious that at no when we have to choose between justice and money, we choose money, right? You know that. So the other.
We choose T-shirts.
Yeah, we choose T-shirt. We prefer. No, of course we would choose justice, and the Dutch law is often held because in the claim code in the Dutch law, you have to be independent from the funder. So the funder cannot instruct you to accept a settlement. So I'm really protected in the Netherlands. Huh?
No.
I don't agree, no. The law is clear. They cannot instruct you to give a settlement, so I'm protected. But we don't have the same reading, I guess. But we are now negotiating a funding agreement with the funder. So we are protected. In other member states, we'll see, but of course, and now we will choose justice, but is the national law protecting us from the influence from the funder? We'll see. And then another question that I thought interesting as well, the support for other complainant and the NGO. Yes, we would love it. We do it, but we have 6 permanent members covering 25 member states, so 6 lawyers covering out. And we did it last week. My colleague Stefan is on the room as well. We're helping data subjects who are just stuck with their procedure in the DPA, but we cannot help everyone. But I'm happy if you want to help us as well to do that. And we might we will do something, I think, this year just to try to collect other cases of people stuck in the DPA. Because we are not the only one to have complaints stuck to the DPA, for sure, that we know. The specific court, I think, is interesting as well. And that's, I think, for me, an advantage of the collective redress and going to court, is that before the court, we will not only invoke the GDPR, but also all the legislation that we want to enforce, DMA, DSA, and everything. And that's another advantage for me. So in court, you can also, you can also make other grounds like DMA, DSA, competition law, unfair competition, and I guess the judge has to be a little bit more specific, I guess, so like the know-how of these judges has to be a little bit more specific. I think it might be interesting, but at the same time, I'm not sure it's really realistic in terms of resources. Are we going to have specific courts just doing that? It's going to be quite burdensome, I guess.
I have the idea courts are already assigning judges to privacy cases that have knowledge. So the courts understand that they have to work on this. So they say, well, you take in the Netherlands, but I hope they will do this in other countries as well. But in the Netherlands, they're trying to educate judges. Yeah,
and in other jurisdictions too.
Yeah.
Any other remarks on these questions? Okay, let me ask a final question then. Are we going to see an EU-wide case that, despite these cross-border... Okay, yes. Proceed.
Teasing. Maybe this year, see you in court. Yeah, maybe this year, yeah.
Okay, well, very exciting. Okay. Well, let's see. We have 3 minutes left. Let's see if we can get one final question and a quick answer. Down the back. Thank you.
Hello, thank you for the very interesting discussion. Maybe I'm too far off now because it's a question that actually concerns the other regulation that's pending in Europe. My name's Helene Leijten, by the way. I was wondering if, especially to the ladies who address the procedural issues and the lack of positive harmonization within the GDPR, do you expect this to be resolved, or at least better, when regarding the DSA, the DMA, and the Draft AI Act? Thank you. Probably not enough in 3 minutes.
Thank you. I think when those legislation were or are being discussed, we did use a lot of the experience of the GDPR, the problems we're seeing materializing on the enforcement now, trying to make sure that those do not repeat on particular DSA, DMA, which are the 2 that have been adopted already, but it's been part of the thinking around the AI Act. You will see probably that on those legislation, the enforcement model is different for several reasons. One of them is, so there are more centralized power and more role for the Commission, which we will see whether it's good or not, but we see some inaction in the Commission on the GDPR side, and I've been quite critical of them, so obviously now they will be in a different position having to enforce themselves, so it's certainly going to be interesting to see what they do, so there's probably avenues around this. But ultimately, on the GDPR, this was not possible. We're protecting a fundamental right, and there are a treaty requirement that means that national authority needs to have a role. So we also hope that the two-way around that, those legislation the enforcement model have been thought differently, learning from GDPR, but also we hope that now seeing those different enforcement and talking about the issue with GDPR, there is also ways to address those issues, because again, I've been critical of the GDPR enforcement, but I do want to say, I strongly support the GDPR, and I think if we're all collectively spending so much resources trying to make it work, is because we believe in the right and want the right behind it to be protected. So it's not a criticism of the law, but it's a frustration of the benefit not existing, and there is avenues with those changes to make it work, and there is a need for a political change, I think, to try to gain some time on all of those court decisions, and then let's enforce it everywhere. But yeah.
Okay, it is now 9. So everyone, thank you to a wonderful panel. I look forward to seeing you sue everyone. Thanks so much.